nigga kill over a bitch, but let a rat keep his wife.
We have the 2920 number calling Jimmy Winfrey, and this is a 536-second connection. Looking down at our chart, who is 2920? That is the phone that we have identified as Cash Money, and
then we identify it with a person that's in the records.
With a person, Brian Williams' phone, as Cash Money. So Brian Williams' Cash Money is calling Jimmy Winfrey, incoming phone call to Jimmy Winfrey at 3:17 for 536 seconds. We then have another incoming call from, again, Cash Money, Brian Williams, at 3:26 a.m. coming in to Jimmy Winfrey for a 5-second phone call. We then have 3:36 a.m. Jimmy Winfrey now goes an outgoing call to incoming Brian Williams Cash Money records at 3:36 for 25 seconds.
At this point in time, after hearing 70-something witnesses and the like, the state, in the court's opinion, has established by preponderance of evidence, at least for the purposes of co-conspirator statements, that that's been established. Now, whether or not the jury buys that is another thing. It's only for the purposes of admissibility in terms of whether or not the court's going to allow the statement. So
what happens in those 2 minutes and 37 seconds of that call, October 22, 2015, it's not been played yet. State put us on notice of it, and I've objected to it on Friday when I got the state's 7 calls. This is not, so I don't know who the speaker is. So the speaker is clearly speaking with a person identified on the call as Mr. Winfrey. Mr. Winfrey's in custody, that's why the call's recorded. Mm-hmm. The unknown speaker says, pursuant to another unknown person, Mr. Winfrey will receive a Porsche vehicle when he is released from custody. That's what I've objected to. So, as you say, I don't disagree with anything the court said about the test. The declarant is not on the call. The declarant is an unknown person. The person on the call is unknown. So I don't know how that is a co-conspirator statement of a third party. It's double hearsay. That's what I wanted to bring to your attention in the motion limit number 5-1.
Is this call that's about 2 minutes in which the unidentified declarant is an unidentified co-conspirator, because in that statement, what the declarant says is, we'll sit down for $250,000 in a Porsche. And Mr. Winfrey doesn't say no. He doesn't say anything. He says, okay, that's my boy. That's my boy. My boy ain't never changed. And so, Your Honor, that statement is furthering the conspiracy as far as concealing what occurred in the conspiracy, which is we will sit down. We will be quiet. We will not say anything for this amount of money. Now, whether or not that happened or not, whether or not he got paid, whether or not he got the Porsche is of no consequence. But this conversation here shows that there's a covering up of the conspiracy, that conspiracy being 1, the gang, and conspiracy 2 being the actual shooting of the bus, Your Honor. And so we believe that this would fall under the co-conspirator hearsay exception.
You can overrule your objection, sir.
Can I have a continuing?
Yes, you may have a continuing objection. Absolutely.
Thank you.
Yeah. What showed it?
I'm not going to tell him that.
What did you tell me that, Sean?
No, he won't tell my shit. He said when you get out, you're going to have a Porsche.
Yeah, tell me to give it to you.
Nah, he told me to do that. He ain't never going to do that, man.
Yeah, he ain't the man.
You know, this shit is Porsche, man.
You ain't got no choice. Hey, man, like my puppy said, you better guard your crib.
Yeah, we sit down for several months for a Porsche in the court meeting.
Hey, come on. Hey, my fine chain now. Hey, Leah. Ain't the man.
So like that, it's a fan, I don't know how you need to get out.
Huh? Hey, come on. Call.
Now, do you remember what time that call was on October 22nd?
It was 21:33, so 9:33 at night.
Okay. And was this call made on Mr. Winfrey's PIN?
No, it was not.
How were you able to find this call?
By doing basically kind of like a reverse search, basically getting the phone numbers that I had previously observed Mr. Winfrey calling to the custodian of records at Cobb County and having them query those phone numbers in their system. So then in doing so, I could see that basically these calls were listed from Winfrey, and then all of a sudden there's a couple calls to that same phone number in another inmate's name. And so I requested those and received those.
And the phone number that you queried, did you have a name associated with that phone number?
I likely did. I need to check the report if you don't mind to refresh my memory.
Well, looking at your report, help refresh your memory.
It would.
What's the name that was associated with the number?
I put it as Shad, or I think you heard Rashad or Shad, something to that effect. I put Shad in my report.
And in listening to the previous jail calls that we listed yesterday, was that name Shad familiar to you, given some of the other calls?
I'll sustain the objection, Mr. Form. You can rephrase.
Had you heard the name Shad prior to listening to this call?
Yes.
Where?
On other jail calls.
Were those jail calls we heard yesterday?
Those are some of them, yes.
In your review of the jail calls, did you hear more calls with this individual by the name of Shad?
Yes, that's correct, yes.
Now, why was this call significant to you?
I heard a money value and a valuable car being discussed in it.
What was the money value you heard?
$250,000, $250,000.
And what was said about the $250,000?
Basically, when he gets out, he'll have a Porsche purchased for him and $250,000.
Now, was that Winfrey who said it, or was that Shad who said that to him?
Shad that said that to Winfrey.
Now, sitting here right now, do you know if Jimmy Winfrey was ever paid $250,000?
I don't know that.
Do you know if he ever received a Porsche?
I don't know that.
Sitting here now, do you know if he ever received any compensation?
I don't know that information.
To you regarding this phone call?
I mean, the fact that he was using someone else's PIN, so it was something that was at least being attempted to be concealed through his own PIN number.
Speculation.
I'll overrule the objection.
Yeah, so that's pretty much it. That my interpretation was there's a reason why it was used on.
Calls for a narrative.
I'll sustain Mr. Form.
What was your interpretation of him calling under a different PIN number?
Objection. Speculation.
Overrule, sir.
There's a reason why it was not on his PIN number.
As it relates to this case, do you know if Jimmy Winfrey ever took a plea in this case?
He did.
In relation to this phone call, how much time passed before he took a plea?
It was approximately a month later, or maybe a month and a day, but a month later.
Sir, do you have an objection?
Okay. Where is the general area of that call?
We go back to our almost first location. So the I-75, I-85 split just north of that area.
Your Honor.
Yes, Mr. Weinstein, you have an objection?
Yeah, you have
Basis.
I do have an objection. It calls for speculation as far as the area of the call. He knows where the cell tower is.
Okay,
But not the call.
speculation is your objection, not the rest of the speaking. I'm going to overrule the objection, sir.
And let me ask you this. With cell phone towers, does it give you an exact pinpoint or a radius or area?
So in these records, this is a location of the tower. So we just have a radius. But going off this, we just have.
Excuse me, Your Honor. I need to raise an objection. Again, it's calling for expert testimony.
I would agree
He's
with
not an
that.
expert.
I'll sustain the objection.
Thank you, Your Honor.
All right, ladies and gentlemen, disregard the last statement about our witness.
Your Honor, I would, without the explanation, I would move to strike his entire.
I just said, jurors to disregard the last statement.
And I would move to strike the previous testimony because.
Overrule, sir. Thank you.
Knowing,
But we covered that, Mr. Steele. We covered that. So what's the additional ruling on it?
knowing that that was not a guilty plea. That was a coerced guilty plea is not a guilty plea.
But we had a discussion at the bench, and I told you that you can inquire into that depending upon what was testified to.
Okay, and I'm going to do that, I propose. But my point is that was so low blow to say a month later a man who was coerced by a Superior Court judge in Cobb County pled guilty that I don't know if I can overcome that, because the impression is that Mr. Winfrey was being rewarded for his guilty plea. The state knows that guilty plea was not.
But we don't know as I mentioned earlier at the bench, we don't know the circumstances of why that particular first guilty plea was rejected. I don't think it's relevant for our purposes. I think the state said they weren't going to get into it. So again, for the second time, because we covered that up at the bench, do you have anything else you wish to add to that? I don't think the state was trying to insinuate anything. If you want to test that or reason, because it might go to bias, it might go to motive to misrepresent. So
it bothers me a great deal, and I'm surprised, but I'm not ever in the mind of the court. It doesn't bother the court because it doesn't go to bias, and the state knows exactly what they did. They know, and you know.
I don't. I don't. The first time that I knew that there was an appellate opinion is when you told me, and that's it. I don't have any other knowledge of that.
Well, I read under opinion, and Winfrey versus State specifically states, and it gives what happened, that the Honorable Judge Staley in Cobb County coerced a human being to enter a guilty plea. For the state of Georgia to say, did he plead guilty a month later, that to me is beyond the pale. And I would like the court to.
I think that's just them asking. They're not asking why, which would be improper. But because it gets into evidence that would be not relevant for this particular proceeding.
I'm like so twisted in my mind. I might be tired, but I don't follow. It should have never come in. It did come in. Now I have to deal with it. You tell me on cross.
I don't think you're conflating, Mr. Steele, the bottom line basis as to why the initial guilty plea was rejected by our appellate court. I'm telling you that I don't know what the basis of that. I still don't know because I didn't read the opinion. The state didn't solicit that or elicit it from the witness. They only just said, hey, he pled guilty on another thing a month later. But the relevant portion that the court heard was the fact that if the jury wants to believe it, is the why as to what Mr. Winfrey may or may not have gotten. And that's the only thing that I heard at this point in time.
I think that, you know, from being a person who loves what we do and loves the courts, I think it's offensive to say and have an agent testify that a guilty plea occurred when everybody knows or should know that that guilty plea is not a guilty plea, it is struck, vacated.
Okay, and Mr. Steele, I'm kind of just telling you that the reason and rationale is not, that would be totally improper for us to get into.
Okay.
I would agree about that, but I don't think that was the state's intention in asking that question. So I'll note your concern for purposes of the record. Okay.
Okay. So I'm going to make a proffer then for about 10 seconds if I may. And I understand what you said. Of course, I'll follow your rule. But I was going to ask Agent Racy. I was going to take the opinion, and I would be perfect to the opinion. And you stated that this man pled guilty. The man actually wanted to go to trial. You can say yes or no. The man was then told by Judge Staley that she doesn't see him winning. She knows the people in Cobb County. They will not like him. He will go to prison. He's going to be sentenced for X number of years, whatever the opinion says, and then he can answer the questions. And I will then ask the court to strike that testimony again, like I did earlier. I understand you're telling me it's not relevant. I believe that it should never come in the first place, and the state of Georgia has misled the jury. He did not plead guilty a month later because we do not recognize that as a guilty. When I say we, you know, our system of what we call just was not, it was perverted.
Okay, all right. State, hold on, Mr. Matthews. The state wish to be heard on that issue?
Yes, Your Honor.
Yes, Ms. Hilton.
Your Honor, first I want to direct the court to an order that was entered on April 9, 2024, in which there was an order in which we cannot discuss the appellate process. What is a fact is that Mr. Winfrey pled a month later. What the state asked, which was my next question, and I forget how I phrased the question, did he have to plea again to the same charges? And he said yes, approximately a year later, to show that there was something that occurred and he had to plea again. But the fact remained that 1 month later, he took a plea. Now, the reason why it was overturned, or the reason why that is the appellate process in which the court has ordered that we cannot discuss and that we cannot get into. What Mr. Steele is speaking of is the reason why it was overturned. That is not for this jury to determine. They can know he pled once and then he had to plea again, which is the plea that we had. Because what I can imagine is on cross-examination, if I did not ask that question, they would have crossed him on it. And so what I did was ask him about a fact, which was a fact, and then did something else occur later on, which is also a fact. And if Mr. Steele is going to go into what occurred during the appellate process, he's going to be assuming facts, not in evidence, because that we never asked him anything about the appellate process.
When did I enter that order?
On April 9, 2024.
Okay, all right. So I've already dealt with that issue, Mr. Steele. I note your objections. So I don't believe that those questions would be relevant for this inquiry based upon my order. So, but I'll note your objection for the record, okay?
Of course. No, I appreciate your kindness. Can I have 2 more statements for this stuff? If you don't mind. I understand the ruling. I just want to make 2 more statements.
Yes.
Okay, thanks. First one is, I don't know how the state can say I was going to, or anyone, maybe I shouldn't speak for other people. I never had a conversation with the prosecution that I would ever cross-examine a witness on a coerced guilty plea.
You made a proffer, that's all. I mean, I don't think we need to spend more time with it, but I'm good.
They took the wind out of the sails. I never, ever was going to do that. Number 2, based upon your ruling, I understand it, and I'd just like you to, I'm going to move for a mistrial because I can't cross in it. If it's denied, can you just do what I've been doing?
I'll deny the motion for mistrial. I'll go ahead and grant you, I will note that you've asked again for mistrial before the positing of the next question, which you've done. All right. Mr. Matthews, did you have something you wanted to tell?
I just wanted to chime in on that issue that has just been addressed by the court. I wanted to,
which issue, sir?
That the Honorable Mr. Steele addressed with the court.
Which one?
The guilty plea.
Okay.
Or lack thereof.
Okay.
So essentially, Your Honor, when the state had Agent Racy on the stand, they started with the jail call. They played the jail call, give you a Porsche and a $250,000. Then they identified this person shot What did you hear him say? Heard a $250,000 Porsche purchase. What was significant about that call? And then, Your Honor, the state said, now did a month later that Jimmy Winfrey plead guilty? In the testimony, the response was he pled. Mr. Steele asked to approach. We approached. He made his points at the bench. After he approached, that's when the state furthered their question and said, hey, did something occur a year later, and did he take another plea? So that was afterwards. So in my mind, Your Honor, that sequence of questioning by the prosecution led the jury to assume and conclude that it was after he heard $250,000, after he heard that a Porsche was going to be given to him, he pled a month later. And I don't think we can unring that. And again, the Winfrey versus State 304 Georgia 94, what Mr. Steele is saying, which I tend to agree with, is that after that Supreme Court reversed that plea, it was not a plea. It was not a guilty plea on that date when he initially pled a month later, because it was reversed. And it was reversed because the Supreme Court determined that the judge improperly, under Uniform Rules of Superior Court 33.5 paragraph A, determined that she improperly involved herself in plea negotiations, and there are a number of quotes. This opportunity is going away.
Okay, what does that have to do with the issue of what was just presented? I get it. The guilty plea was faulty for whatever reason.
And the state knew that, and they had a responsibility to know that. This is very.
But we covered that on order on the 9th. We covered that at the bench. Mr. Steele already went through it. Do you have anything new you want to tell me?
Just that on the 9th, the state knew that. They knew that before they asked that question this morning.
Anything else, sir?
So I'm intimating to the court that door has been opened in our estimation. The court will have to rule on it.
I don't believe that door has been opened. I believe that at this point in time, it's going to stay closed.